Hello, neighbor. I'm Robert Burns, and welcome once again to another edition of Sound Off Louisiana. And I know everyone is thrilled with last night's LSU victory over Alabama. And we'll go ahead and kind of calm back down to earth because I know you were probably as excited as I was, particularly if you had a money line bet on LSU, as I happen to have had. But let's go ahead and get back to the daily grind. I had let everyone know that during the upcoming week, that was a week ago, that there would be a important trial taking place on Thursday, November the 3rd. And that trial entailed the Louisiana State Troopers Association versus the Louisiana State Police Commission with regard to making political campaign contributions. It is the LSPC's stand that such contributions are in violation of the Constitution. In the LSTA's stand, they believe that they have the constitutional right to engage in such activity. Just to give you a real brief background, all of this came to the surface in early 2016 when two gentlemen filed complaints. One is retired Lieutenant Leon Bucky Miet, whom I think just about everybody who's ever followed this blog is bound to have some familiarity with, and also retired Captain Jesse Scott Perry. And they filed complaints, and we're going to give you the link for Mr. Perry's complaint, which he filed in early 2016 with regard to campaign contributions that were made in the 2015 election cycle. And one of the witnesses who was called at Thursday's court hearing by the LSPC was Jesse Scott Perry. And I have to believe that Lenore Feeney had to be a little bit taken aback, or probably more than a little bit taken aback, at the testimony that Mr. Perry gave. And I can only say that as a courtroom observer, it seems he's had a complete and teetotal change of heart about all of this. He emphasized that he is sympathetic. With the benefit of hindsight, he can understand the need for the LSTA to do this. And he said, but at the time that he filed his complaint, he just didn't see how they could be in accordance with the law of having done so, of making the contribution. So he also readily admitted that in January or February of 2020, he had approached the LSTA about being reinstated as a full-blown member. And COVID came along, and so as you know, we all kind of got trapped in our homes and nobody could do much of anything for quite a while. And so his yearning to be back in the LSTA kind of got put on the back burner, but he did testify that he revitalized it in late 2021 and met with four gentlemen, Mark Oxley, James O'Quinn, Rodney Hyatt, and Hackley Willis. And I believe it was Mr. Willis who communicated to Mr. Perry that, look, we're going to go ahead and allow you back in for purposes of attending functions and things of this nature, but your full-blown membership will have to put on hold until this whole litigation is resolved. And when I say litigation, I'm meaning the very thing that we had the court hearing on. Not a court hearing, it was full-blown trial. And so I want to break away just for a few moments and let the other complainant, that being retired Lieutenant Leon Bucky Miet, weigh in on his thoughts about the testimony of Jesse Scott Perry. Let's break away for just a few moments. And as I just indicated, we have broken away, and it is my distinct pleasure to have joining us today for today's Sound Off, retired Lieutenant Leon Bucky Miet. And as I just explained to our viewers, there was some somewhat surprising testimony on the part of Jesse Scott Perry at Thursday's court hearing. Specifically, while he was called by the LSPC, he gave testimony that was incredibly friendly to the LSTA. He readily admitted that he could see the need for making the political contributions. And he readily admitted that he has been trying for some time to regain membership in the LSTA. He has been granted already privileges to return to functions that they hold, and he indicated that they told him that his full-blown membership would just have to wait until the conclusion of this present court hearing. And as I said, we have retired Lieutenant Leon Bucky Miet, and just thought we'd get his thoughts on that little development at Thursday's court hearing. So, Mr. Miet, why don't you go ahead and chime in?
Yeah, Robert. After I learned of Justice Scott Perry's testimony, that he in fact reached out 2 different times to Rodney Hyatt, Hackley Willis, James O'Quinn, and Mark Oxley in an attempt to be reinstated to the LSTA with full-blown LSTA membership. And apparently they told him from his own testimony that he could start attending meetings, and although he wouldn't be a full-blown member, they would consider that after they had the second meeting, they would consider his full-blown membership after his court testimony. And my concern at this point is, did that have any effect on his testimony? Was his testimony in any way affected by his deep desire, apparently, to become a full-blown member of the LSTA? The very agency that I believe that has brought the Louisiana State Police down to the level they are today. And I'm very concerned and very disappointed in Scott Perry. I thought we were on the same page, and after his testimony, I can assure you we are not on the same page. I have been on many occasions in my nearly 80 years of life, I've been disappointed, let down, and hurt by many people, but Mr. Perry made my top 5 list with his testimony.
Wow.
And that's all I can say about that issue.
Well, and we certainly appreciate you being willing to join us today. And, you know, I kind of felt like that would be your thoughts on the matter, and glad you were willing to verbalize them to us. And we look forward to, you know, hearing more from you, perhaps as more State Police Commission meetings transpire, and certainly on the final outcome of this litigation. So thank you so much for joining us today, Mr. Miet, and thank you for being such a dedicated Sound Off Louisiana subscriber.
Well, just keep up the good work, Robert, because sunshine is the best disinfectant, and we need to keep the sunshine on the Louisiana State Police. You have a great day.
Sounds great, and you do the same, Bucky. All right, I think that retired Lieutenant Leon Bucky Miet made his sentiments quite well known, and we certainly appreciate him weighing in. We expected that to be his reaction, and when we first contacted him on Thursday evening to indicate what had transpired, I think it's beneficial that he's had the 72 hours to cool off a little bit. But as you can tell, he's disheartened and disappointed. So let me go ahead. I'm going to just quickly kind of let everyone know what all took place in the trial. It was about a 5-hour trial, so don't worry. I'm only going to hit high points because trust me, there was some put you to sleep material. In fact, at one point, Judge Johnson just kicked back in his chair with his head staring at the ceiling. And I too, I will admit, I did fall off to sleep during the testimony of Hackley Willis. It didn't last long, so I doubt I missed anything earth-shattering, but this was not stuff that is going to make headlines anywhere. And in fact, Sound Off Louisiana has been the only one who's covered anything about this lawsuit. So I'm going to hit the high points. In the opening remarks by Mary White, she's the attorney for the LSTA, I'm not going to elaborate much on that because she just said we need clarity, we need clarity. You know, and she said they believe we have the constitutional right to do this. Well, we knew that. That's why they filed the lawsuit. So the judge did ask during her opening remarks. He said, "Do you see any limitations?" And basically that because the LSTA is a private organization, they are of the belief that they ought to be able to make contributions as well as endorse candidates. So I'll let that do it for Ms. White's opening remarks. Ms. Feeney, who was the attorney for the LSPC, and I do want to say she brought her A game, okay? If this court case is adjudicated based on the material presented, Miss Feeney came to play hardball. She played hardball. She brought her A game, and I believe the ruling would go in LSPC's favor if you base strictly on the arguments presented to the court. My prediction, however, is that it will not. The ultimate ruling will, and I've been very open about that, the ultimate ruling in this is, in my opinion, not going to go the way of the side that posed the best arguments. But I want to make sure everyone knows she brought her A game, all right? Now, in her opening commentary, she stressed things like that a trooper doesn't put his badge down and suddenly become a non-trooper. The entity and the trooper's activities, they're all intertwined. And until 1990, they had complete restrictions on all of this because they were civil service employees. They fell under the master umbrella of civil service. But in 1990, the LSPC was formed. I'm having to look down at my notes because there's just no way anybody could remember all of this. So if you see me looking down, that's why. She said the whole thing harkened back to the Huey Long days and the lockbox, and basically that they're not seeking clarity. All right, they are flat out seeking an expansion of what the Constitution allows them to do. And she mentioned that if they want to change this, that the LSPC was enacted through a constitutional amendment, and if they want to change it, likewise, it needs to be changed by a constitutional amendment. She stressed that there is constitutional amendment number 3, and I believe that's going to be on the December ballot, but I can't, no, I'm sorry, I believe it's on the November ballot. And apparently, now she said that is to allow civil service employees, she says that's to merely take pictures, be seen in photos for a relative that's campaigning. I will take her word at that. I just know that most everybody has interpreted that amendment to be far different and that you would have far more activities. And if that's all it was restricted to, then all I can say is the sponsors of that amendment have not done a great job of communicating it, because that likely would change my vote. I don't early vote. I never have and never will. But I'm going to have to do a little more research because I was initially a flat no. But based on what she said, and I have no reason to doubt that Ms. Feeney would appear in front of an officer of the court and state something that wasn't correct. So based on what she's saying, I may be much more inclined to go with a yes, but I think that an awful lot of people sure didn't know that that's all it did. So, but I got off on a little bit of tangent, there, but she again talked about these circulars and because circular, and now we're not going to get bogged down into the weeds here, this kind of stuff will put you to sleep. 190 and 191 had been rescinded, and so she said circular 48, which has been in effect, I believe, since August the 8th of 95, according to my notes. She said it still prevails, and it is flatly not permissible to do this. And that's basically the high point. Now, those were all in her opening remarks. I haven't gotten to any witnesses yet, but I think I've pretty well covered most of what she covered in her opening remarks. Now, I'm going to have to rely less on my notes here because the first witness up, and he took longer than every other witness combined, and that was former LSTA President Jay O'Quan. And I can pretty much remember what all he had to say because I thought his testimony was probably the most dominating influence of all the testimony that was given. He did say that being president of the LSTA is a thankless job, but he emphasized that everything was going along fine. These political contributions had been being made since 1998. That testimony was also reinforced by Charlie Dupuy. We'll get to him in just a moment. But he really stressed that, and I guess he has a point in this. I mean, there's just no denying it, I guess. He said every year we come out with a budget, and one of the first lines on that budget, it's itemized out political contributions. And he said, we've never tried to hide that. And when Lenore Feeney said, well, do you specify to whom the contributions will be made when you come out with that budget? And he said, well, no, because at that point we haven't vetted out to know who is going to be a favorable candidate to law enforcement or who may be unfavorable. So at that point, no, we haven't necessarily designated to whom we will make the contributions, but we have been making contributions every year. And he said, and then all of a sudden these complaints get filed in late 2015, early 2016, and he said, his words now, he said, we got pushed to the sidelines. And that's where we've been ever since. We are at a competitive disadvantage to other law enforcement agencies who can engage in these activities. And he named a couple. I don't know that I'm going to get bogged down into that because I'm looking quickly over my notes. I know he noticed the Fraternal Order of Police and one other, but I'm not going to get bogged down onto that. He stressed, because I'm trying to just hit the high points, he stressed that this has really hamstrung us. We've had our hands tied behind our backs, and we could not go in and make these contributions. Now, he was listed on the witness list of both the LSPC and the LSTA. And as part of Lenore Feeney's bringing her hardball bat, because she didn't play softball, she stressed that, well, are you not attending these meetings on state police time at which you get $46 an hour? So if anybody didn't know, Jay O'Quann's former rate for pay was $46 an hour, which I equate to be right around $110,000 a year, give or take. And I believe that was just the straight rate. It wouldn't include overtime, which Mr. Mead made a public records request some time back and saw that he was getting quite a bit of overtime. But at any rate, she was saying that you leave your home up in North Louisiana. I believe that, don't scratch that because that may have been Hackley Willis. But at any rate, you're using company vehicle. The gas is paid for. When she got O'Quann to admit that he routinely attended LSPC meetings and was being paid by LSP. And all of that was basically to clearly establish that, as she said, things are intertwined here, and trying to separate, as she said, you can't just put your badge down and say, well, for now, I'm not a trooper. The other organization, I have it written down, the National Troopers Coalition, I believe, beyond the Fraternal Order of Police. But at one point, Judge Johnson asked to see the relevance of that. So, and I think that that's an indication of how this did get pretty bogged down. And he characterized the LST as being a labor organization, though it is not an actual union. He said that the reason everyone is so fearful to engage in political activity now is because of all these complaints. They fear that they could lose their jobs over engaging in that activity. He said that when Circular 190 came out, he felt, this is a quote, he felt threatened, he felt shocked, he felt isolated, he felt targeted. Circular 190 and 191 were rescinded, replaced by 202, but they said they didn't feel that provided any clarity whatsoever. And in fact, he said it actually added to the confusion. And as I said before, he said, we have been put on the sidelines, we've been hamstrung, and he said, out of sheer frustration, we filed this lawsuit, which has now been going on for 4.5 years. He said everything was going along just fine. I've already said that, but from 1998 till 2015, it wasn't until these complaints got filed that everything just blew up. And let's see, I think I've covered about everything that Ms. Feeney covered in the cross, or most of the high points, because as I said, you can't cover everything. I took extensive notes on this. Let's see. The 2015 campaign contributions totaled, according to Mr. O'Quann, approximately $14,700. With regard to the David Young matter, he said that the press and so forth didn't have a clear understanding and that this was a mistake. Ms. Feeney said, didn't it get significant coverage? And Mr. O'Quinn said, well, only by a couple of blogs. And she said, you didn't notice it being covered by the Advocate? And he had a very interesting response. He said, and I quote, well, WAFB didn't cover it. I'll pause right there. In other words, if it doesn't make WAFB, it isn't of significance. Look, folks, I'm not going to go off on this tangent, but I gave up on WAFB a long time ago, okay? I firmly believe that they are highly protective of Louisiana State Police. I'll stop right there because I don't want to get dragged into that, but I don't watch WAFB News and have not for a number of years now. I think most of you know I do watch Channel 2, WBRZ, and I especially like Chris Nakamoto's coverage of state police. And just as a quick little side, I think we need to all have some congratulations for Chris Nakamoto. He is one of, I believe it's 10, it might be 12, but I believe it's only 10 finalists for the DuPont Award, and that is a very prestigious award. I hope he gets it because I think that would be really nice for a Baton Rouge-based journalist to receive such a prestigious award. But even the fact that he's a finalist, I think we all need to commend him because they awarded him that based on his LSP coverage and specifically Ronald Green. So I digress a bit on that, but I did find it interesting that Mr. O'Quinn feels like that if WAFB doesn't cover it, it's not newsworthy. They talked about the consent order, $5,000 fine, and from what I took down on here, Ms. Feeney wanted to try to find out from him, well, how do you find out who you're going to endorse? And he had said that each troop affiliate member kind of polls the troopers in that troop, and he even said sometimes I have to come and make a vote that I don't agree with. But he said he does that because he wants to fulfill his role to represent the troopers from his troop, and sometimes that may be at odds with what he personally would choose to vote, but according to him, that's how they would go about selecting whom they would endorse and or make financial contributions to. Of course, all of that ended in 2016 because of the complaints, one of which was from Jesse Scott Perry. So let me go ahead and move on from Mr. O'Quinn because, as I said, he took up the vast majority of time, but I don't want this video to run excessively long. Charlie Dupuy, when he got up, he reiterated that, hey, look, now he served as an LSP from 1990 to 2018. He was the chief of staff, which, as I have said in many posts, the chief of staff is, for the most extent, the de facto colonel of state police. Surely they have a colonel who has the title, but Charlie Dupuy was the chief of staff, the lieutenant colonel under Edmondson when these complaints got filed. And they said, did these complaints come to your attention? And he said, of course they did. And they asked, did you call for an investigation? And he said, absolutely not. And he was emphatic that his reason for not calling for an investigation is because, well, there was absolutely nothing done wrong here. And he had said that's the whole reason we hired an executive director, that there was a time when the LSTA apparently didn't have an executive director, but he said we knew that as troopers we couldn't do this, so he said that's the sole reason we hired an executive director in the first place. So, and he said that the LSTA had been incredibly beneficial to troopers because he said that many years ago there was bad pay and things of this nature. In fact, he said when he started as a trooper, he was making $17,000 a year, and he said, and he was single, and he said, and he struggled to make it at $17,000 a year, so he didn't even want to think about what it would be like to be married and have to support kids on $17,000 a year. And he said that there was a 3% accrual rate, which they really needed to get to 3.33%. And he said the LSTA is the one that managed to get that accomplished. He also said that that I believe that it was a pay raise in 2014. Don't hold me to that year, though, but that pay raise, which was smaller than a much larger pay raise that came further along, it was along the lines of 30 to 35% across the board, but that particular pay raise was going to be totally a function of renewing a cigarette tax. And he said that the LSTA is the one who stepped up to the plate, got that cigarette tax renewed, and that and I'm quoting him, every single trooper is indebted to the LSTA for having done that. So I think I've covered most everything. Yeah, the cigarette tax and that was and how everyone was indebted to the LSTA for that. And that was, he just said, thank God for the LSTA, or where would we be? And there wasn't a lot of time spent on the cross-examination, but I will say this, and this was not Charlie Dupuy, this was J.O. Quinn. He had said, how did this whole thing turn out? The investigation on the campaign contributions from 2015, and Mr. O'Quinn said, well, we hired an outside law firm, and he said, I can't remember the gentleman's name, Miss Feeney had to help him, that it was Taylor Townsend, said, and he determined that there was no wrongdoing done because we did everything we did on the advice of our attorney. Now, that was reiterated by several others that were up, I think most notably Charlie Dupuy, and Floyd Falcon, who had not said the first word. He had let Mary White do everything, but by about the third or fourth time that they said that, well, we did no wrongdoing because our attorney gave us this guidance, Floyd just flat out raised his hand to be acknowledged by the judge, and he said, look, I did not do this. So I'm not sure what attorney it may have been that gave them the guidance. And I apologize let me just say this, trying to cover that part's accurate, but the $46 an hour and coming all the way from North Louisiana, I'm now looking over my notes for Hackley Willis. So that was what Lenore Feeney brought out, that, hey, you're paid from the time you leave your home. Now, she did talk about with J.O. Quinn being paid while you're at commission meetings and so forth, but it is Hackley Willis that the $46 an hour rate was thrown out, and that includes traveling from his home. He's in an LSP vehicle. There's a state-issued vehicle, paid state gas, and so she also stressed that to both of them that, hey, you have the ability to go and testify on bills for or against. You're not prohibited from doing that. Am I correct? Well, yes, that is correct. And said you just can't make direct contributions to a candidate. And particularly Mr. O'Quinn said that, well, you have no idea, you don't understand how badly that ties our hands. He said, when a candidate has a fundraiser and they sell tickets, and we have no ability to buy these tickets and be in attendance at the fundraisers, at the events, we lose access. We lose critical access to these important lawmakers or potentially the governor. And she said, well, surely you could arrange a meeting with the governor. And I do remember Mr. O'Quinn said, yeah, good luck with that, arranging a meeting with the governor if you're not able to interact with him at one of these events. So let's go ahead and move on to the defense, which was much shorter than the plaintiffs. Hanneman took the stand. He basically said that the General Circular 48 would still govern the day, and that reaction was not good when those circulars were issued. Then we had Colonel Davis, and his main testimony was that beyond any constitutional considerations, there's also a procedural order, and that Davis did say, just like everybody else, they had nobody had any knowledge that this was going on, the contributions and so forth, until everything blew up in 2016. But he did stress that Lenore would tell him which procedural order and whatnot, and I believe it's 901-46. But don't hold me to that. I wrote very quickly on this. Procedural order 901/46 that would give him the authority to discipline a trooper who engaged in these types of activities. Now, and I have written down, we've already talked about Jesse Scott Perry, so I'm not going to spend very long on him, but he too, he says that the LSTA told him that, hey, we didn't do anything wrong here because we acted on the advice of attorney. And I wrote Attorney Floyd Falcon, but later Floyd raised his hand, as I'm indicating, and say, look, I am not responsible for this. So as I said, Mr. Perry, in January and February of 2020, he sought full reinstatement to the LSTA. That, because of COVID, all got put on the back burner and wasn't up at forefront. In late 2021, he said he was still strongly interested in rejoining. You've already seen the surprise that was for former or retired Lieutenant Leon Bucky Miet. I wrote down the four that he met with: Mark Oxley, Rodney Hyatt, Hackley Willis, and James O'Quinn. And according to my notes, it was Hackley Willis who they met as a group, and they said that he can go ahead and attend certain functions, but that his complete reinstatement as a full-blown member would have to await this conclusion of this present litigation. He did say they terminated his membership. We already knew that. They terminated four individuals who had membership when this whole campaign thing blew up, these contributions. Only two of those four had filed complaints, but I guess two others were quite sympathetic because there were a total of four that had their memberships revoked when all of this blew up. He said, this is again Jesse Scott Perry, he said now he can see where this is very much needed, I guess with the benefit of hindsight, and he said that he understands their need to do this, but he had reservations when he filed the complaint that just didn't conform with what the law said. And he said, I'm sympathetic to the LSPA's cause and very much want to be readmitted. And let's move on to the final witness that was up there for the defense, and that was Eula Simeon. And he was very emphatic that the Constitution is clear. And he said this is it's impermissible activity. And he said that while the LSTA kept saying, well, we need clarity, he said the reality is what they wanted is permission. And he said when we would not give them permission to engage in an activity which we firmly believe, and he is emphatic that the Constitution's wording is clear, they were upset and they filed this lawsuit. Now, I will say this, and we're going to have a good bit of the text part of this feature will focus on this. Miss White, the attorney for the LSTA, did ask Mr. Simeon. She said, well, has your law firm made political contributions since you joined the commission? Because, see, that too is not allowed. A commissioner cannot make campaign contributions. It's not just the troopers that are barred from this, it's also the commissioners. In fact, 3 of Bobby Jindal's commissioners had to step down no sooner did John Bell Edwards take office, and that was a separate complaint, and all 3 of those commissioners had to resign. So she posed the question. She didn't say, did you? She said, did your law firm make political contributions since you have been on the LSPC? And his answer was quite emphatic. He said, my law firm most certainly has not made campaign contributions since I've been on the LSPC. Well, we're going to give you the links for, again, Leon Bucky Miet, who showed up at an LSPC meeting. He called for 3, not the 3 that were way back then. They're already gone. He called for 3 current members who are still sitting members today. He called for them to resign. We're going to give you the link. You're welcome to watch the video. One of those 3, Jared Caruso Ricky, was not pleased at all at being basically what he said blindsided and told Mr. Miet that he was grandstanding. and Mr. Ricky insisted upon equal time, and he produced a considerable amount of documentation to explain away what happened in his situation. We're going to give you the link for that because he had said that he certainly hoped that the press would devote equal time to him. Now, Sound Off was not the only one to cover that matter, so did the Advocate. And I will state that we published every shred of documents that Mr. Ricky supplied. However, I'll point out the Advocate never did. So also we're going to give you the link for the next meeting. And it was at that meeting that Mr. Ricky chose to dress down Mr. Miet about him coming up and, as he said, grandstanding. But we're also going to give you the link. I mean, there's no denying it. It is what it is. We're going to give you the direct link for the contributions made by Simeon and Simeon. And that's a law firm, folks. And where you will see highlighted the contributions to the campaign of John Bell Edwards. So I'll let it go at that. Miss White did not follow up. I was a little bit surprised that she didn't, but she didn't. And only she may know why on that. So with that, that's pretty much the trial. They did not even do closing arguments. They decided that would all be reduced to they would reduce them to writing because, as is so commonly the practice for Judge Johnson, and I have been in quite a number of cases that he has presided over, so I have the routine down, including the one that I argued. And by the way, I will just say this. I said that Miss Feeney brought her A game. She did. She did an outstanding job in this trial on Thursday. As many of you are aware, I also tried a case myself, pro se, only about 5 or 6 months ago in front of Judge Johnson. And I will say that the LSPC filed a last-second amicus brief, and I will also say that Ms. Feeney did an extraordinary job in that hearing, too. I was not about to give such credit at the time because, well, let's face it, nobody can outdo Robert Burns arguing in front of a judge. But in seriousness, because it's no secret, I'm not happy with the way that the judge ruled in that case. But it is what it is. But I'm not going to take away from her that she did a good job, and quite a bit better job than the Metairie law firm that had no clue the distinction between letters of counseling and letters of reprimand, but no need to rehash all that. So here's the bottom line. As Judge Johnson is so inclined to do, he wants each side to present their findings of fact, conclusions of law, and the judgment that they would like the court to sign. Now, both sides want transcripts. Both sides want transcripts of the hearing. And let me just say this, once the LSPC has transcript, I'm going to make public records request and publish it because while I took extensive notes, I think many people are interested in reading actually what happened in that courtroom, what got said. And naturally, I'm not giving you verbatim. We'd be here for hours. But at any rate, the court reporter indicated that because they have the trial next week, it's going to take her at least 2 weeks to get the transcripts completed. And so the judge said December the 5th of 2022, so we're literally looking at about 30 days. That's when the proposed findings of fact, conclusions of law, and judgments need to be submitted to him. And sometime thereafter, he will, as is his practice, sign one of them, at which time one side is going to be quite thrilled and the other side won't be so happy. But that will also be after the runoff for the current election cycle, noting that Judge Johnson is in a quest to join the First Circuit Court of Appeals. So that's the time frame that we're looking at. I have tried to, I know this video ran a little longer than I had hoped, but I tried to get you all of the high points. Trust me, it was better than sitting through a full-blown 5.5 hour of arguing. So we'll just have to wait and see. But I think the big news of the day had to be the stunning and surprising testimony of Jesse Scott Perry. So thank you once again for tuning into this Sound Off, and we'll just hang tight, see how the judge rules, and see if there are any pending appeals, which my guess is no matter which side prevails, there's going to be an appeal, and ultimately it will be the Supreme Court who decides this issue. So thank you so much for your dedication. Hope everybody enjoyed the LSU win. And if you happen to place a little money on it, I'm sure you enjoyed it even more. So we look forward to bringing you another Sound Off Louisiana feature real soon. Thank you once again.